welcome to the March edition of HR Hot Topics. I'm your host, Jodi Schafer, and maybe we should title this HR Recurring Topics because yes, folks, again, we're talking about earned sick time. For those of you watching this that are not Michigan employers, probably just skip this month, right? Because earned sick time is a Michigan-specific law, requires all employers, with the exception of the federal government, to offer earned sick time to almost all employees. And it was set to take effect on the 21st of February. So unless you've been living under a rock, you've heard me talk about this for many, many months now. And as we were leading up to February 21st, still the legislature hadn't made any significant moves, and we were all hoping and praying, and it's March, so wishing on four-leaf clovers, I don't know, but we were calling our senators and we were doing everything we could to try to encourage the legislature to make some necessary amendments to this law before the 21st. And in true government style, they waited until the 11th hour, literally the wee hours of the morning on the 21st, but they did come to a bipartisan solution that made some pretty significant changes to both earned sick time and minimum wage here in Michigan. Both of those were very, very welcome developments. We were thrilled. We wish it hadn't happened on the effective date. That made things a little chaotic, but good changes nonetheless, and so I'm going to spend this month's episode talking about what some of those changes are. So I'm going to have in front of me this at a glance document. Again, if you've been following these videos or you've been on our website looking for ESTA resources, this will be a familiar looking document to you. But I've gone in and updated all of it because the amendments that were passed on the 21st affect several aspects of this at-a-glance document. And so I'm just going to walk through some of that today. There are several webinars that have been going on the week leading up to this and the weeks following, sure. So if you're a part of a professional association and you are doing business in Michigan, I would encourage you to reach out to your associations and find out if they're going to be hosting a webinar in ESTA. I know we will continue to put out resources on this, and we'll probably do some sort of educational offering as well for those of you wanting to make sure that you are in compliance. So a couple of things that I want to just start with. The effective date for this bill, I keep calling it a bill, for this law, it's like it's real now. So the effective date for this law was the 21st of February, 2025. That is still the effective date of this law, unless you fall in one of two categories. So, and this is new, this is one of the changes that was made. If you are a small employer, which is now defined as 10 or less employees, before it was less than 10, meaning 9 or less, but now in the revised language, it's 10 or less employees. If you have 10 or less employees, you're considered a small employer for the purposes of this law, and your effective date for compliance is not the 21st of February, it is the 1st of October, 2025. That is the date that you have to be in compliance, and that is the date that your accrual amounts would begin to calculate. The other category that has a slightly different effective date is for folks who are considered a new business. Again, this is a change in the law. If you did not have an employee on your payroll prior to February 21st, 2022, you're considered a new business. And so you don't have to comply with this law until you add your first employee to the payroll, and then your effective date is 3 years from that date of hire. So you have a little time, right? If you're just getting started, you've got no one on the payroll, you're not complying with this, and then once you add your very first employee to payroll, you have 3 years from the date of hire of that first employee to get into compliance with this act. So just a couple carve-out categories there that didn't exist prior, but by and large, for most of you watching this, February 21st is still going to be the date of compliance. Now, a few other changes around kind of who's affected by this. Most employees are going to be covered under earned sick time. Now, I know in prior episodes and conversations around earned sick time, we said, look, if they're getting a W-2, they're probably going to have to be covered under earned sick time, regardless of how many hours they work, if they're temporary, seasonal, part-time, salaried, hourly, right? If they're getting a W-2, then chances are pretty good they're going to be covered under this. That is still the case with a couple exceptions. One, independent contractors are most likely going to be excluded, so that's the same. But there are a few carve-outs now in the new legislation. One of those is unpaid trainees or unpaid interns. So if they're not getting paid for that internship or that training program, then they do not have to accrue earned sick time. Another is individuals that are employed under the Youth Employment Standards Act, so folks that are 17 and younger, assuming that you as the employer are following all of the rules of the Youth Employment Standards Act, meaning you have a work permit on file for them, and you're making sure that they're following the hours restrictions and some of the dangerous job restrictions, et cetera. But if you're in compliance with the Youth Standards Act, then the folks that are 17 years and younger could also be carved out from compliance with this. And then another one that's interesting, and I think this was meant to be sort of like a gig worker, but it doesn't specifically say gig. And what it says is those working in accordance with a policy that allows the individual to schedule his or her own hours. So an employee that can schedule their own time, and the employer does not have any minimum limits on the number of hours that have to be scheduled in a certain period of time, and there's no adverse employment action taken for folks that schedule minimal hours or no hours from time to time. So again, I think that was really meant to carve out like gig employees, even if they're W-2, but I'm getting calls on like, well, what about my sub-hygienists? Right? Even if I pay them a W-2, but they work very, very infrequently, if I call with a sub-assignment, they can say no. There's no adverse action if they don't take it. Potentially, those folks could be carved out. I also got a call from a mental health clinic. They employ therapists. The therapists make their own schedule. There's no minimum hours they have to work. And so the question is, could all of those be carved out? Potentially. This all has to kind of be sorted out by LEO, the Department of Labor and Economic Opportunity. They have to give some guidance and clarification on some of these new wordings, sections, but potentially. So I think if you have employees, even if they're paid on a W-2, but they might fall in that scheduling category, it would be worth a call to an employment law attorney to get their take on it. So just some carve-outs that didn't exist before. Another change here is when can an employee begin using their accrued time? Now, in the original act, it said employers had the option to impose a 90-day wait period, so the accrual had to begin on the effective date, but you could have employees wait up to 90 days to be able to access their banks. The revision is a little bit different. What it says is for all of your existing staff, anybody that was on staff with you as of the effective date, those folks have to be able to access their bank immediately. But for anyone you hire that is a new employee for you after the effective date, and I'm saying that because depending on your size, you're going to have a different effective date for this. But any new hire you have after the effective date, you can choose to impose a 120-day wait period for them. Again, it's employer choice here, and it would only apply to new hires after the effective date, so not your existing staff. And that was really meant, I think, to, in a way, protect seasonal employees that are working for short periods of time. So even though the accrual obligation still exists and you're still, tracking those banks and they have hours to use, they can't actually tap into them until 120 days out if you choose that. And so it creates a little bit more cushion for employers with seasonal staff. Another change has to do with the maximum usage. So for employers that have more than 10 employees, their requirement hasn't changed. It's a max usage of 72 hours in a given year. Now, again, that's not the maximum on the accrual. They could potentially accrue more than that, but they're capped on usage. So 72 hours, that hasn't changed. What has changed is for small employers. Again, 10 employees or less, you can cap usage at 40 hours a year. Now, previously it was like 40 hours paid, 32 hours unpaid. They got rid of the 32 hours unpaid. It's just 40 hours for small employers. Another change had to do with front loading of banks. So this is a big one. I think this one and this combined bank PTO changes are the ones that for many of my employers are like, oh, thank God, okay? So here's the deal with front loading. In the prior law, it wasn't expressly prohibited. You could front load, but there really wasn't a reason to do it because, again, this time was like a hands-off time. You had to allow the employee to use it with no notice, and you couldn't take any disciplinary action for them doing so. And so did you really want to give them a whole year's worth right up front? And you still had to track throughout the year, so you're making a guess at how many hours to load in the beginning, but you were still on the hook for making sure that the record keeping and tracking was accurate at any given point in time. And you had to allow unlimited carryover. So for a lot of folks, the front loading didn't make a lot of sense. But now, under the amended language, there are some potential incentives if you decide to front load. So here's how the front loading works. Again, it's your choice. You do not have to front load these hours. You can choose to front load the hours. If you choose to front load the hours for your full-time staff, you can choose to front load the annual usage max. So for your large employers, 11 plus, that's 72 hours. You can just pick 72 and put them in their bank at the start of your benefit year. And for my employers that have 10 or less employees, your annual usage max would be 40. So you could load 40 hours at the start of your benefit year. And you no longer would have to track the actual accrual for that year. You could just take that annual usage max, and that's the number you'd load, and you would be considered in compliance. So from a tracking perspective, you kind of get out of a few of the tracking requirements, which is great. The other nice thing if you choose to front load is that you do not have to allow for carryover. You could, but you don't have to, because again, you're reloading those banks in full on day one of the benefit year. So if you choose to front load, you can pick the number you're going to front load based on annual max usage. You can choose whether or not you want to allow for carryover, and if so, in what amounts. Or you could choose to pay out at the end of the benefit year for unused time, if you want to. There's still no requirement that you have to pay out for unused time, but if you want to, if that's your standard practice because you're trying to incentivize folks to be judicious with their absences and their leaves, and you want to pay out for unused hours so that they choose to stay at work versus take that day off, you can choose to do that in this case. So those are the front-loaded options. Now for your part-time employees, because I said full-time folks, you choose the annual max usage amount, 72 or 40. But for your part-time employees, you can also front load. And what you'd have to do is do an estimate of hours they're expected to work in that coming year. And then you would base the accrual on that, so the 1 hour for every 30 worked, and that would come up with your annual number that you'd front load at the start of the benefit year. But there's some documentation required. So you'd have to make sure that that part-time employee knew in writing what their anticipated work schedule is, how many sick hours that's going to equate to, and then for your part-timers, you do have to make sure that you true up at some point throughout the year to make sure that your estimate was accurate. And if it wasn't, and they actually should have gotten more hours than you awarded them at the start of the year, you have to make them whole. So a little different for part-timers, but still the option is there. The other thing that I think is really nice, again, with this idea of rollover is that if you're offering the front-loaded system, carryover is optional for you. If you're offering it on an accrual basis, so it's an earn-as-you-go kind of system, you have to allow for carryover unless you choose to pay out for unused hours. So now you have the option, okay? But in that accrual system, if you're going to do the carryover option versus the payout option, there is now a maximum limit on carryover hours that didn't exist before. So if you're doing an accrual system and you're choosing to carry over versus pay out, the max carryover, if you are an employer with 11 plus employees, is 72 hours. Again, assuming they have that many hours to carry over. And for employers with 10 or less, the max carryover is now 40. So we have a cap now on carryover for those accrual systems. Another question that we're getting here is the rehire component. Again, I'm talking about payout, and I'm saying, hey, you now have the option to pay out unused hours if you want to do that. Previously, there was a bit of a concern, like, I don't know if you necessarily want to pay out these hours, because if you rehire this employee in 6 months, you had to, give them their entire bank back again, even if you'd paid out for it. There's been a change there too. So now what it says is that if you rehire the employee in 2 months, not 6, 2, if you rehire them in 2 months, then yes, they get access to that previous bank, unless you chose to pay it out at the time of separation. So it makes a little bit more sense. And again, that narrowing of time of rehire from 6 to 2 was meant to, kind of assist folks that use a lot of seasonal staff. So that was another change. Another big one has to do with PTO banks and combined banks and increments of time. So I'll hit on that. First, the increments of time. If you recall, the way the law was previously written, it said you couldn't ask them to use ESTA in more than 1 hour increments, but you had to offer it in the smallest amount of time your payroll system could track. So it was kind of like the standard was the smallest amount of time they could track, up to 1 hour. That's sort of how it was worded. In the amended version, it's flipped, and it says ESTA can be used in 1 hour increments or the smallest time that the employer system can track, which seems to imply the employer has the choice here, that 1 hour is the default unless you choose to use a smaller increment of time. You still can't require them to use it in more than 1 hour chunks, but now 1 hour can be the default, which thank God, because that was just going to be a nightmare. Let's talk about PTO banks for a moment. So this was another frustration, I think, under the previous law. The law said, yeah, you don't have to require a separate bank of time for this, so long as whatever bank you're offering meets all the terms and conditions of ESTA. And I don't have a single employer that wanted to subject all of their paid time off to these very restrictive requirements out of ESTA. So most of our employers were going to now start carving out and creating a second bank of time. The revised language makes a combined bank much, much easier to offer. And what it basically says is that if you're currently offering a bank of time, no matter how you label it PTO, you label it sick/vacation, personal days, whatever you label it, it doesn't matter. If that combined bank of time provides at least enough hours in it that it meets the ESTA requirement, and the employee can use those hours for any purpose, including all the purposes under ESTA, then you're in compliance. So what a breath of fresh air, okay? So if you're currently offering paid time off in one bucket and combined, it's at least the 1 hour for every 30 work, that math is going to work out. And people have, they can start accruing it on day one, or maybe you front load and they can use it for any reason, then you're good. Now, I love this. I want to just read you something from the Labor and Economic Opportunities FAQs, which is the enforcement agency behind this law. Their FAQs have been updated, so if you're curious on that, you can go and read those, and I'll link to them too. But one of the questions said, if my employer created a combined bank of time that includes PTO, vacation, and sick, am I entitled to more sick time if I use all of that allotted time on vacation? And this was the question from the previous law, it wasn't really clear, right? And Leo's response is no. If the employer had provided you with the time to use as PTO, vacation, or sick, and you chose to use it as vacation, you don't get extra time. As long as I've given you the chunk of hours and said you can use it how you wish, including for sick, then it's up to you to choose how to use those hours. And if you burn through them for something other than sick, you don't get additional sick hours on top of it. So this was huge, okay? So I think for many of you, this is the big one where you're like, okay, maybe I'm not gonna have to make such significant changes to my paid time off policies. I might still have to bump them a little bit. Maybe I still have to offer paid time off for part-timers or seasonal folks that didn't have it before. but you may not have to do wholesale changes to your existing time off policy. So that was big. Another thing that changed is, and this is another big one, remember in the prior law, it said something like, you can't discipline or take any adverse employment action for an employee exercising their rights under this act. And one of the rights was you should request notice for foreseeable events no more than 7 days in advance. And if it's unforeseeable, then as soon as practical. And it never defined practical, right? And employers are like, oh my gosh, like scheduling is going to be a nightmare if I can't enforce my notice or call-in procedures for ESTA. That was another big change that happened through this bipartisan amendment. Thank the Lord. So now you can have a policy that says for foreseeable events, no more than 7 days notice. Okay, so that hasn't changed. But for unforeseeable events, employers now have the choice. They can either say as soon as practical, which I don't think any of you are going to want to say that, or they can say in accordance with our standard notice and call-in provisions. If you are requiring employees to follow standard notice and call-in provisions for ESTA time, you do have to make sure that those provisions are in writing so employees know what they are, that employees have access to those, that if you make any changes to them, they have at least 5 days advance notice of the change, and that the policy does give them the option to notify you potentially after the start of that ESTA absence. There are some times when an employee is incapacitated and they weren't able to call in prior to the scheduled start time of their shift. So as long as your policy allows for those rare circumstances where an employee could call in, post the start of their shift and still be within provisions, then you're fine. And the beautiful thing is now an employer can discipline an employee if they don't follow the notice or call-in procedures, or they're using ESTA for a purpose other than intended. So you still can't discipline because they used it appropriately or requested it. That's still a hands-off thing. But if they didn't follow your notice procedures when trying to use it, or they used it for a purpose that isn't approved in the law, then you could step in and take disciplinary action. Before, it was, a total hands-off approach. So this is a huge win, I think, for employers, and it goes a long way to helping just maintain schedule and kind of due course of business. One other note here, and it has to do with the enforcement component of this. This was the other big one. Employers were terrified because the original law included a private right of action, so the employee could go right to an attorney and not necessarily just the enforcement agency if they thought they'd been wronged, and a rebuttable presumption, meaning the employer was assumed guilty unless otherwise proven innocent. And that was a very high burden of proof. The revised language has struck both of those provisions. No longer can an employee go right to an attorney if they feel that ESTA has not been followed by their employer, and no longer is there a rebuttable presumption. Now, the amended language specifically says that the Department of Labor and Economic Opportunity, LEO, will be the enforcement agency for this law, which makes compliance a lot easier because now we can rely much more heavily on the guidance that LEO gives us through their FAQs. Before it was like, well, it was great that LEO thinks this, but what would an attorney say, right? Now it reinforces the fact that LEO is in fact the enforcement agency, the attorney piece is cut out of it, and that is huge for all of us. So what do you have to do now, okay? Here's what you have to do. One, you have to figure out when your effective date is for compliance. If you are 11 plus employees, your effective date has come and gone. It's the 21st of February. If you have 10 or less, your effective date is the 1st of October. And if you're a brand new business, then potentially you have an even longer roadmap, or if you're covered under a collective bargaining agreement that's currently in effect. The CBA would stand until it's ready for renewal post-effective date, and then it would have to come into compliance. So figure out your effective date, and then what the new law says, the revised version, is that you have 30 days from that effective date to provide written notice to your employees about the changes that are coming. So it gives you a little bit of time here to kind of get your house in order. And I know many of you had a contingency plan ready to go, and then these amendments turned it all on its head. So you've got a little bit of time here, but 30 days from the effective date, you've got to get written notice out to your employees, and then all new hires going forward around ESTA, what your rules are going to be. We're updating all of our resources on our website, one of which is a sample notification letter that you can take a look at. Take some time, peruse all of those resources. We'll update the resources listing too for Michigan Chamber and Department of Labor and Economic Opportunity. So you've got all of those in one spot. If you have any questions, you can reach out to me directly, Jodi Schafer at workwithhrm.com. And if you're not already on the email list, I would encourage you to join it because that's where we're going to send out updates. And certainly if we do any kind of informational session or educational seminar on this, that's how you'll be notified of that as well. So with that, I'll leave you. I'll join you again in April, where hopefully, luck of the Irish here, we can talk about anything else other than earned sick time. Let's see how well we do.